Maryland's unfairly restrictive permit issuance process denies citizens their Second Amendment right to bear arms and does not match federal and most states' laws in its restrictions. Maryland is one of only 4 states which solely issues special permits to its residents. Maryland's carry permit process involves requirements which exclude a majority of applicants for gun permits, leaving very few law-abiding citizens and many more criminals utilizing illegally obtained and carried weapons to commit crimes against an unsuspecting public. According to the Maryland State Police website, one must be a private detective, have multiple verifiable threats against their life, or provide proof of business ownership and regular deposits and withdrawals of large quantities of cash. Gun control laws have developed over a long period of time in the United States. We have a long-standing tradition protecting our right to bear arms. In fact, the 1698 English Bill of Rights reads, "Protestants may have arms for their defense." Pennsylvania's original state constitution read that the people have a right to bear arms for the defense of themselves and the state. In 1939, the court rejected a Second Amendment challenge to the National Firearms Act, which had made it a crime to transport machine guns and sawed-off shotguns across state lines. The court disagreed in its decisions in the United States v. Miller, saying that in the absence of any evidence tending to show that the possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that this weapon is any part of the ordinary military equipment or that it could be used to contribute to the common defense. The repeal of the District of Columbia's handgun ban in 2008 was a more recent break in the handgun laws. A D.C. lawyer, Robert Levy, a member of the Cato Institute, was a libertarian organization dedicated to strong constitutional protections for the people as opposed to the government. D.C.'s handgun laws prohibited residents from possessing a handgun even if it was in their own home. The case surrounded a worker, Dick Heller, a guard at the Federal Judicial Center, who carried a gun at work but was not allowed to take it home, and a woman, Shelley Parker, who lived in a high-crime neighborhood of D.C. and wanted a pistol to protect herself. A federal judge overruled their Second Amendment claim, citing the Miller case. However, the U.S. Court of Appeals ruled that the D.C. law clearly violated the Second Amendment. Justice Scalia's opinion stated the two sides of the case perfectly. One view, held by the city and dissenters, believes it protects only the right to possess and carry a firearm in connection with military service. The other view, endorsed by the court's majority, holds that it protects the individual right to possess a firearm unconnected with service in the militia, and that to use an arm for traditionally lawful purposes, such as self-defense within the home. Scalia concluded that because the inherent right of self-defense has been central to the Second Amendment right, the D.C. ban was unconstitutional. It amounts to a prohibition on an entire class of arms that is overwhelmingly chosen by American society for that lawful purpose. It fits perfectly if one knows the history. That history showed us that the way tyrants had eliminated a militia consisting of all able-bodied men was not by banning the militia, but by simply taking away the people's arms. The prefatory clause does not suggest that preserving the militia was the only reason Americans valued the ancient right. Most undoubtedly, though, thought it was even more important for self-defense and hunting. But that threat of the new federal government would destroy the citizens' militia by taking away their arms was the reason that right, unlike other relinquished rights, was codified in the written Constitution. Maryland's recent case, Raymond Woolard versus Marcus Brown, who was the Secretary of the Maryland State Police, had a huge impact on our rights to carry in Maryland. Judge Legg's opinion from the official court documents found on the state of Maryland's case search indicate Mr. Legg's views on the Maryland's oppressive law. He said, "A law that burdens the exercise of a enumerated constitutional right by simply making that right more difficult to exercise cannot be considered reasonably adapted to government interests, no matter how substantial that interest may be. Maryland's goal of minimizing the proliferation of handguns among those who do not have a demonstrated need for them is not a permissible method of preventing crime or ensuring public safety. It burdens the right too broadly. At the bottom, this case rests on a simple proposition. If the government wishes to burden a right guaranteed by the Constitution, it may do so provided that it can show a satisfactory justification and a sufficiently adapted method. The showing, however, is always the government's to make. A citizen may not be required to offer a good and substantial reason why he should be permitted to exercise his rights. The rights existent is all the reason he needs. And while the significant ruling has been stayed per the request of the Attorney General of Maryland, the case is set to be heard in the Fourth Circuit Court of Appeals around May 29, 2012. Finally, I would like to point out that there are a number of ridiculous rumors about gun violence which can be swiftly ostracized. According to the Cato Institute, there is a theory that thousands of children die each year from gun accidents. In 1997, the last year in which data was available, 142 children died in gun accidents. That is less than the accidents involving bikes, space heaters, or drownings. Gun shows. People seem to believe that gun shows are responsible for guns being sold to criminals. This is not true. At most, 2% of guns used by criminals were purchased at gun shows. States that have gun laws restricting the concealed carry weapons have lower crime rates than those which do not restrict carry. According to the charts here, from the Gale Encyclopedia of American Law, there is a clear correlation between reasonable gun carry and lower crime rates. According to the Cato Institute, the 31 states that have shall issue laws or allowing private citizens to carry concealed weapons have, on average, a 24% lower crime rate, a 19% lower murder rate, and a 39% lower robbery rate than states that forbid concealed weapons. In fact, the 9 states with the lowest violent crime rates are all right-to-carry states. Remarkably, guns are used for self-defense in more than 2 million times a year, 3 to 5 times the estimated number of violent crimes committed with guns. There is a belief that the waiting periods for guns cause lower crime rates. This is not true. Numerous studies have been conducted on the effects of waiting periods, both before and after the federal Brady Bill was passed in 1993. Those studies consistently show that there is no correlation between waiting periods and murder or robbery rates. Florida State University professor Gary Clack analyzed data from every U.S. city with a population over 100,000 and found that waiting periods had no statistically significant effect. Ultimately, repealing oppressive and unconstitutional laws regarding firearms has a positive effect on crime. Maryland's recent overturn of the obsessively restrictive requirements for possessing a carry permit is a major step towards a safer state.